and welcome to the second installment of our Privacy and Access series, which the Ziffren Institute is co-sponsoring with our colleagues at the Institute for Technology, Law, and Policy here at UCLA. My name is Mark McKenna, and I'm the faculty co-director of the Ziffren Institute along with my colleague, Doug Lichtman. We have a great program for you today with four terrific panelists who are here to talk about the changing landscape in privacy regulation. In the interest of time, I'm just going to do a very short introduction of each of them. You can find complete bios for all of our speakers at the link that Lex Mata is just posting now. Natasha Amlani is a graduate of UCLA Law and currently an associate at Perkins Coie here in Los Angeles, where her practice focuses on privacy counseling and litigation and data breach response. Natasha also advises global platform companies on content moderation decisions, intermediary liability, and data disclosure requests from civil and criminal litigants and law enforcement. Ryan Harkins is Senior Director of Public Policy at Microsoft. In that role, he works on issues relating to technology and civil liberties, including state and federal privacy legislation, the regulation of AI, and voting rights. Bill McGovern is Associate Dean and Professor at the University of Minnesota School of Law. He specializes in information law, including data privacy, intellectual property, communications and technology, and free speech. Bill's also the author of a leading casebook on privacy and data protection law, a casebook that now might have the distinction of needing more radical revision from edition to edition than any other casebook in use in modern law schools. And finally, Jennifer Urban is Clinical Professor of Law at the University of California, Berkeley School of Law, where she's Director of Policy Initiatives at the Samuelson Law, Technology, and Public Policy Clinic. She was appointed by California Governor Gavin Newsom in March of 2021 to be the inaugural chair of the California Privacy Protection Agency Board. The California Privacy Protection Agency was created by the California Privacy Rights Act of 2020 and is charged with implementing and enforcing the California Consumer Privacy Act of 2018. So thanks so much to all of you for being here. Very much looking forward to the conversation. Bill, I'm going to start with you. Bill, so you and Anupam Chandra and Margot Kaminsky wrote a really terrific paper a couple of years ago called Catalyzing Privacy Law, where you considered GDPR and the California Consumer Privacy Act. And we're trying to think about which of those two regimes might turn out to be the global standard. So I wondered if you might start us by talking a little bit about the landscape that you were seeing when you wrote that paper and about what you've seen that's changed over the last couple of years.
Sure, I'm happy to start that way. And thank you, Mark, and everyone at the Ziffren and Institute for Technology, Law, and Policy for hosting this. Right, the paper actually came out last year in the Minnesota Law Review. It was called Catalyzing Privacy Law, and I wrote it with Anupam Chandra of Georgetown and Margot Kaminsky of Colorado. And our thesis was there had been all this talk in media and government circles about the EU's GDPR being the spur of new privacy law, being the catalyzing factor. But the laws we've seen in the US so far, and those that appear to be in the potential near future, are really different from the GDPR in some important ways. So we actually found that, as often is the case, the real catalyst has been California through the CCPA, which passed in 2018 as a way of heading off a proposed ballot initiative, and then augmented by the CPRA, which was the 2020 ballot initiative that passed. And of course, Jennifer's going to have a lot more to say about that, I'm sure. But those are the broadest consumer privacy laws to be enacted anywhere in the US for many years up to that time. And it set off a real flurry of activity in state legislatures. So again, we feel like the catalyzing was from California. One of the first places it was evident was in Washington state, which I'm sure Ryan will have more to say about. There, with support of Microsoft, there was a bill that's come very close to passing several times, has not mostly passed, but that bill is somewhat different from the California bill. I'm sure Ryan might tell us why, but it's still much closer to California than it is to the GDPR. In the last year, new laws passed in Virginia and Colorado, which definitely showed their lineage to the Washington bill, which shows its lineage to the California bill. And then just last week, to show you how frequently I have to revise my teaching texts, last week, Utah passed its own state consumer privacy law, bringing to 4 the total of state laws that have now come out since California. They all follow a similar general outline. I said on Twitter at the time, and I will say here, those were not the states that I had on my bingo card for comprehensive state consumer privacy law. There was a lot of places where there was more talk, but it turned out so far less action. But I think that underscores how much is bubbling up that states can sort of surprise us. I mean, there's a bill moving in Indiana now, in Florida. There's lots of things happening. I know Ryan's following them closely, and maybe others will be able to chime in about that. So lots of state laws happening, but really only inspired in broad concept by the GDPR. Really, in terms of what they do, they have the same core. And what I talked about in my paper with those co-authors is there's a difference between a data protection approach to privacy and a consumer protection approach. Right? Under data protection, which is a more European style model, it tends to be comprehensive and cover all personal data. It tends to be backed up by kind of constitutional and human rights notions about data privacy, even in a commercial setting. And it has a default of collection is forbidden. In Europe, you can only collect and process personal data if there's something in the law that says that you can. Otherwise, not allowed. In the US, under the FTC, under these state laws, we have a different, more transactional approach. It's a consumer protection approach. It doesn't apply broadly to everybody. It applies only to a set of businesses that are defined as qualifying. These state laws have certain thresholds of amount of revenue and amount of data they use that are the cutoffs for whether they qualify, whether a business has to follow the rules, and excludes data covered by other sectoral regulations. So, right, if you're covered by the health privacy law, HIPAA, then you're not covered by this law. If you're covered by the Gramm-Leach-Bliley Act that governs financial data, you're not covered by this law. So it applies more narrowly. It does not have the same sort of constitutional backstop that we see in European law. And our default is the opposite. In America, you can collect and process whatever data you want unless there's some specific law that comes in and says you can't. In other words, it's more of a blacklist than a whitelist of data processing justifications. So what the bills in the US do mostly, I'd just say they do 3 broad things, and I'll leave it to my co-panelists to fill in the details. They increase transparency around collection of consumer data. They require certain forms of institutional privacy management in companies, that they have to do more to assess and mitigate the risks to data privacy. And then they provide some data subject rights, some things that we as individuals whose information is collected into these databases are empowered to do, particularly to opt out of certain kinds of transfers and some rights of access and even some limited rights of deletion. But not nearly so broad as what the GDPR does, and in any of these areas, but still, meaningful steps forward. The future prospects, just the last part of what I'll say, Mark, is, I think this proliferation of state laws could really pressure Congress to act. We talked about that in the article that you referenced. But, there was this had happened before, right? We had data breach notification laws requiring companies to notify consumers if there have been big security breaches in the company. Once again, California passed the first one. It caught on, and then pretty soon it spread really fast. Everyone said, oh my goodness, all these laws are a little bit different from each other. We have to have uniformity. Congress has to step in. Bills were introduced in Congress. They never passed. And we now have 51 data breach laws covering the 50 states and the District of Columbia in the United States. Many of them have small differences from each other. I'd say business has basically adjusted to that reality and has figured out how to make it work. And Congress never did step in with a uniform data breach rule. So the same thing could happen here, but there are some differences. One is, of course, these laws are broader than just data breach. Another is that there's some really new attitudes about tech companies in Silicon Valley in our political discourse that could help fuel more bipartisan approaches to these issues. Republicans and Democrats both support privacy law, even if they have different points of emphasis. And there's then the question of whether Congress can do anything right now in its current state of dysfunction. There are a bunch of obstacles. We'll probably talk about them. They really are fighting about how much a federal law should preempt state laws, how it should be enforced, whether there should be private lawsuits. But there's more energy around this than there has been in a long, long time. And that's really directly attributable to the fact that California has these two new laws on the books that really, it's a big state, huge state. It's a state with so much technology. So many of the headquarters and the centers of gravity are here. And I think everyone's going to be acting in response to California, catalyzed by California for a long time to come.
Great, Bill, thanks. That's a really great start. Ryan, I'm sure there's a lot in there that you have thoughts about. So I'll just start it by asking, I know you've been involved in and on the ground in many of these states where some of these things have been coming. So I guess I'm curious about your thoughts about why this is happening at the state level, why the explosion now, why it's coming faster in some states than in others, and kind of, what you think about what that suggests about the prospects of or the future of federal legislation.
Sure. Thank you, Mark, and thank you for having me. I agree with Bill that California clearly catalyzed things by passing CCPA in 2018. And it was a development that we at Microsoft were supportive of behind the scenes in trying to help get the law passed. And it's something we celebrated because we've been calling for comprehensive privacy legislation in the United States since 2005. And there are a number of reasons why we have long called for comprehensive privacy legislation, but the long and the short of it is that we see legitimate concerns that more and more of the public have raised. The industry writ large has lost a lot of the trust that the public used to have in technology. And we think the only way to earn that trust back is to have credible laws pass that will provide consumers with real concrete protections while allowing businesses to continue to innovate and use data responsibly. So I think the short answer as to why we're seeing this happen at the states is Congress hasn't acted. And we've seen the rest of the world race ahead of the United States in starting to address concerns around privacy and data protection. The European Union, of course, as Bill was mentioning, has long had a different approach than the United States. They passed the Data Protection Directive in 1995, and the General Data Protection Regulation, or GDPR, of course, was merely an update to the Data Protection Directive in many ways. But we've seen a growing list of countries around the world start to tackle the issue as well and pass really copycat or their own versions of GDPR. So California passes the CCPA in 2018, which was great because it was the first comprehensive privacy law in this country's history. And then you started to see, a wave of states introduce either versions of the CCPA or a bill in Washington state, the Washington Privacy Act, which was initially intended by Senator Carlisle, who was the sponsor here, as an effort to go further than CCPA went at the time, but to do so using concepts and terms that came from the GDPR. And with his thinking anyway, being that these are terms and concepts that companies ought to already be familiar with if they are doing business in Europe. And so you saw, for example, in the Washington Privacy Act, efforts to include a right to correct, which was not in the CCPA, the original version. You saw efforts to include a broader deletion right. CCPA's deletion right applies to personal information collected from a consumer, which means it arguably won't apply to data obtained from a third-party source like a data broker or to inferences derived from personal information. You saw an effort to broaden the opt-out right. So don't give consumers merely the right to opt out of the sale of their personal information, but expand that to include sale, as well as the processing of personal data for targeted advertising, and for consequential profiling in furtherance of the provision of insurance, credit, etc. Of course, California still was interested in staying relevant, and so passed a ballot initiative in November of 2020, the California Privacy Rights Act, or CIPRA, which expanded CCPA in some significant ways. And although those two models still look different on the surface, substantively, in our view anyway, they arrive at very similar places. And of course, CIPRA now added, among other things, the correction right, most significantly, created a new data protection agency in this country, and gave initially the Attorney General and then the Data Protection Agency significant rulemaking authority. We have seen other states, as you noted, take action. Virginia last year, of course, became the second state to pass a privacy law, and a law which is modeled on the Washington State Privacy Act, which, fourth time in a row, of course, this year died once again. Turns out fourth time was not the charm. But Virginia's law is very similar, but is frankly a bit weaker in some key respects. It has a narrower definition of sale. Its definition of de-identified data is arguably not quite as robust. It does not have as robust of a definition of consent, because it does not bar obtaining consent via dark patterns, among other things. And then we saw Colorado follow suit by passing a law which was stronger than Virginia's in some key respects. And interestingly enough, included a universal or global privacy control, something which is similar to the opt-out signal that was contained in CIPRA, which is a way of making it easier for consumers to exercise the right to opt out of certain processing activities in one place and at one time. But we continue to see lots of activity in the states. I mean, this year alone, I'm tracking about 70 comprehensive privacy bills across 30 states. And if anyone asks, yes, I have read every one. And as Bill mentioned, we saw Utah pass a bill, the Utah legislature passed a bill last week, in a bill which, to be perfectly honest, we have serious concerns about. Because in our view, it is a bill that appears on its surface to provide privacy protections to consumers, but in reality has certain definitional aspects baked in to create the groundwork for people to argue that it won't apply to modern online data sets. So it has a narrower definition of personal data, a broader definition of de-identified data and of aggregate data. It includes the concept of pseudonymous data. And at the end of the day, that may lead some to argue that the bill does not apply to data maintained with cookie IDs or IP addresses or device identifiers, the kinds of data sets that are used to track consumers online today. So we hope that Utah decides to fix some of those aspects of their bill, and that bill does not start to pick up speed or traction in other states. But I suspect you will see it introduced in other places as well. I'm not even mentioning a third model that we've seen released, which was a bill that the Uniform Law Commission produced last year, a bill which frankly we have similar concerns about as we do with the Utah bill. It appears to have been designed so that it would not apply to online advertising, which in our view, if you're going to pass a privacy law in 2021, it has to apply to online advertising. I have a lot more I could say, but in the interest of time, Mark, perhaps I will stop there and leave further remarks for our discussion.
Yeah, great. And I'm sure all of you guys will have reactions. Natasha, I saw you nodding along with a whole bunch of things, so you should feel free to kind of frame your comments here in whatever way you want. But what I was most interested in is like you began practicing as this flurry of activity at the state level was happening. I'm curious if you could give us some insight as to kind of how are your clients treating this situation? How are you giving advice given the differences across different states? Are people picking kind of a baseline state and just saying that's the most restrictive, I'll set my activity to that level? Like, can you give us some insight into like how you are thinking about this in terms of client advice?
Yeah, definitely. So as you rightly noted, I started practicing in this area in 2018. So right after the CCPA was proposed. So my first 2 years as a lawyer were really focused on helping businesses focus their efforts on CCPA compliance. And so part of that is, identifying trends in existing laws. Anytime there's a new law, specifically with the CCPA or like with the new Utah law, sort of identifying trends and areas and overlap and thinking through how a business can leverage its existing compliance efforts for one law to another. And part of that is thinking through how can your compliance efforts be broad enough to cover multiple laws. And so as a lawyer thinking through compliance, you're thinking through how can you sort of write language that's broad enough to cover obligations under different privacy regimes, so that in your privacy policy, for example, you don't have multiple iterations of similar provisions, which not only helps just with efficiency, but also helps keep a privacy policy more accessible and readable to consumers. And then part of that is also thinking through where a business is currently operating, what market it's targeting, and what it might expand to. So we will work with startup companies, for example, that are planning to focus and operate only in the US, but then in 6 months or a year, plan to expand to the EU. And so for us as privacy lawyers, we're thinking through, well, maybe at this point, while we're drafting your initial privacy policy, maybe we just add in now any obligations or disclosures that you might need for GDPR compliance. So that way, business progress and expansion is installed 6 months or a year down the road, because privacy policy has to go through another iteration and be run through all of the different teams in a business and then updated. And then the same thing sort of applies when you're thinking through compliance with an emerging laws. So when the CCPA was initially introduced, a lot of our large clients were thinking through and following all of the initial iteration, as well as all of the changes in the law as soon as they were released. And we were helping businesses think through compliance even at that early stage, far before the law was ever in effect and far before it was even final. And so part of that and helping a company think through how to best use its resources is staying on top of all of the trends. So for me, I would attend the Senate Judiciary hearings of the California legislature to think through and make sure that I understood how the law was going to be changed. Like with the private right of action, clients would ask us, do we think that's going to go away? Do we think it's going to be narrowed? And we would be able to say, well, no, all of the changes and what the Senate Judiciary Committee is thinking through is focused on this other provision. They're pretty sure that this is going to stay. So let's think through what we can focus on now to make sure that, a business is compliant. And so in terms of thinking through what a business already has, let's say for GDPR compliance, a business needs to know what business units within the larger company have access to EU data. And so that could require sending a questionnaire to 25 or 30 different business units within a company and asking them what data they have. And so if we know that this business is likely subject to CCPA, in a year or two, just advising at that point that we add a question for, well, does this business unit also have access to California personal data? And that way, we're ahead of the curve and you're not having to sort of corral all of these different business units where they might, not necessarily view like a legal compliance function as their most important priority. So you're sort of asking them, can we get a response on this, and you're just far ahead of the curve. And it's something that relies on something you would have to do for an existing law anyway. And then another part of that is advocacy efforts. So when you see a new law, or like Ryan was saying, if you identify issues with a proposed law, thinking through how can you and what avenues are there for you to raise those concerns and find ways to propose a change before a law goes into effect. And so for businesses, we did that with the CCPA and would think through, if the legislator has proposed something, but the impact on the business is not readily apparent, or it seems like no one has really thought through what the cost of that's going to be, making sure that we're able to raise that, or raise, if this might pose a conflict with a federal law subject to another interpretation, and then raising those either as part of the legislative process or as part of the CCPA, participating in the formal rulemaking process and opportunities for engagement there. So I would attend the CCPA forums on proposed regulations, and then we would submit comments through that process to the Attorney General's office to essentially identify what we thought would be the problem with the regulation, explaining what the impact that would have on a business, and then when appropriate, sort of proposing a narrower regulation or explaining why we think that it could change. And then the last part of that is setting up strong compliance plans so that you are able to effectively operate within a patchwork of laws. So like Bill mentioned, every state has a different data breach notification law. And like Bill said, businesses have adjusted to how to handle that. And that's something that I regularly help businesses with. And so, part of that is different notification thresholds for when you need to notify individual consumers of when there's been a data breach, when you need to notify the state attorney general, and if you need to notify like the consumer reporting agency, and then different timing thresholds for part of that, as well as what triggers your obligation in terms of what is personal data as covered by that state. So what we've done is we'll map out all of those obligations, and then basically make sure that we as lawyers are prepared to say, like, okay, well, you have 10 states and 10 consumers in Alabama, we're getting close to the notification threshold. Once we get to X number, we'll need to issue this notification, and having all of those like mapped out. So my firm, Perkins Coie, we have like a security breach notification chart where you can go and look at what is required for each state. And that's another example of where advocacy can be really important, because some of the sector-specific privacy law, like GLBA for financial institutions or HIPAA for health data, have their own obligations for data breach notification. And so if for example, if a state was going to create a new or a modified data breach obligation, a health company business or a financial institution could advocate for a carve out for that essentially says that if you are complying with specifically one of those laws, you are exempt from that state laws. And so some state data breach notifications do have that, but that adds another layer of not just the state laws, but also the sector specific laws and how they interact with those.
Great, thank you. So Jennifer, certainly not last but not least, I knew that there would be a lot of discussion about the role of the board here and the role of California, especially as being a model for the other states. So I know that folks on here are really interested in hearing whatever you can tell us about sort of how you guys have gone about the process of building the board, and how you're operating at this point, what the scope of your authority is. Anything else you feel like you might share? I'm sure people are interested in hearing your perspective.
Sure, and thanks for having me. This is wonderful and really enjoyable. I've really enjoyed listening to the other speakers who set out a good background framework for me to talk about one of the innovations in the California Privacy Rights Act, which is the California Privacy Protection Agency. So before I begin, I do need to be clear that I'm speaking only for myself. I'm not speaking for the agency or for its board. And to the extent that I speak as an academic, again, it's only for myself, not for my university. But I'm excited to be here to talk about the California Privacy Protection Agency. As was mentioned, the ballot initiative from 2020 established a new agency and gave it various authorities in order to implement and enforce the California Consumer Privacy Act of 2018. I am going to quibble a little bit with Bill. I see the California regime as, and this is Jennifer as an academic, and only herself, as a melding of fundamentals and the traditional notice and choice regime that we've used in the US, hopefully made actually actionable. And the reason why I say that is because Californians actually do have a right to privacy in our state constitution. And our rights, our laws flow from that fundamental right to privacy. And the agency itself is charged in its statute with protecting the fundamental privacy rights of natural persons with respect to use of their personal information. So that sounds very much like human rights and fundamental constitutional rights. But to back up and just talk about the agency a little bit. In the initiative, the Privacy Protection Agency is conceived as an independent watchdog whose mission is to protect consumer privacy, that should ensure that businesses and consumers are well informed about their rights and obligations, and should vigorously enforce the law against businesses that violate consumers' privacy rights. And that is why it is now charged with protecting fundamental privacy rights. It is to implement the law with the goal of strengthening consumer privacy while giving attention to the impact on business and innovation. Overall, the agency is modeled to some degree on data protection authorities and other places. It is intended to be an expert agency. And in that, it is, as far as I know, the first agency in the United States with full administrative powers that's focused on privacy, something that other countries have had for quite a while now, but something that is a bit of an experiment in the United States. I will say the Washington law that died did have an agency as well, a specialist agency as one of its components, but the other states that have passed comprehensive regimes so far haven't included something like the CPPA. The CPPA has some wide-ranging responsibilities. It is directed to engage in administrative rulemaking and given the authority to do that, administrative enforcement, public awareness, which I consider to be one of the most important of those three being sort of the major responsibilities. Because California is a large state, it's a diverse state, it has many communities of regular, ordinary Californians, as well as different kinds of businesses. I think it's really important for the agency to be facilitating the use of rights by all Californians and all communities, and for all businesses to have access to information about their responsibilities. And then sort of as belt and suspenders, the agency also is to provide guidance to businesses, to consumers, and then a variety of other activities, including advising the legislature on things that may be within its expertise, monitoring technological and business developments, which I also think is important, and cooperating with other jurisdictions in the United States and around the world in order to have a harmonized approach to privacy protection. So it very much looks like these are some of the functions that other data protection authorities undertake. And then Mark, you asked about sort of what is going on. The board, the agency is governed by a board. I'm the chairperson of the board. The board was appointed not quite a year ago. And so we are now simultaneously building the agency, now under the leadership of our executive director, Ashkan Sultani, and the staff that he's rapidly building, and working towards fulfilling some of our statutory responsibilities as set out in the timeline of the CPRA and the CCPA. So we are to engage in rulemaking on a long list of things to help flesh out some of the law. And that is anticipated by July 1st. To do this, though, the authority for the rulemaking has to transfer from the Attorney General, which had authority before the agency came into being, to the agency. And for reasons I won't go into, there's a process around this, and it will happen in April, after which we will be able to introduce a draft rulemaking package. And so that will still be in Q2, but we announced in our last board meeting that it'll probably be finished Q3 or Q4. The law takes effect, the new parts of the law, the amendments, the CPRA amendments and CCPA take effect on July 1st, 2023. But personal information is covered under both sets of protections as of January of this year, so a couple of months ago. And then the agency's enforcement power kicks in July of 2023. And once we have enforcement power, we will be in charge of administrative enforcement, working in collaboration with DOJ, which will still have authority over civil enforcement. So while we can't do our formal rulemaking package adoption until we have authority, we are free to engage in what are called preliminary rulemaking activities, and we've been actively doing that. So already in September, we issued an invitation for comments and asked stakeholders to give us their initial thoughts. I keep realizing these binders are comments we received, about 900 pages of those. So we have a lot of information and fodder to work with. From those, we have regular public meetings where people are welcome to comment, and we are holding information sessions, which will be sort of instructional sessions on various topics later this month, and then stakeholder hearings in April. And all of that is preliminary to the formal rulemaking. We can do that before the authority transfers. And I hope that everyone will look out for that and participate, because the more information we have, the better, as we're working on the rulemaking package. Now, there are some complexities to how the agency has to operate under California's very robust transparency and open meeting laws. It's often not intuitive to folks, including people who work in this space, that the other board members and I, who hold the authority of the agency, meaning we have to vote on any of the decisions, actually can't talk to one another outside of a properly noticed public board meeting. So that means that we can't just sort of get together and try to figure out what we think is a good draft and then release it. We have to have these conversations in public. And that means the public gets a seat at the table. It also means that it's not quite as efficient as when other agencies engage in this process, and that is purposeful. The Bagley-Keene Open Meeting Act actually says that it values transparency over efficiency. So I always try to mention that because it can be confusing for people. And then I'm happy to talk about any more of this as we get into discussion, but I think that should give people the basic idea of what we are and what we're doing right now.
Yeah, thank you. That's a great start. So I want to invite all of you guys watching along at home to feel free to submit questions in the Q&A function. I have a couple of them, one of which is related to the question that came up, but I also want to invite you guys to kind of react and respond to each other however you want. The question that was asked, though, which is kind of a long, I'll ask a version of it, which is, when I first started teaching privacy and started using Bill's book, the presentation of it was kind of like, well, there's no comprehensive privacy regulation in the United States. And then as soon as Europe comes along and creates it, the sense was everybody, that would just get exported around the world and everybody would just sort of adopt that as a standard. Is the flurry of state activity and the idea that companies are actually paying attention to what's going on, does that suggest that that hypothesis was wrong? That people actually don't just set their baselines around a single kind of standard, or that there are particular things these laws are doing that require some deviation from that? Like how do we think about the relationship between sort of that way of thinking about the world and all the activity that we're seeing right now?
I'm happy to start, Mark. And I would say I don't think that hypothesis is necessarily wrong, because we do see GDPR proliferating around the world and serving as the model, the primary model for other countries as they are considering their own data protection laws. Whether companies or other organizations will gear their business practices and compliance efforts to GDPR seems to me to depend upon the industry and whether they're doing business outside of the United States. And to some extent, this bleeds into what I think are some of the key challenges and key issues or sticking points that have prevented more privacy laws from passing in this country. I mean, the number one issue continues to be enforcement and whether a bill will have a private right of action or not. And that is far and away the issue that has killed privacy legislation in Washington state, but it's also killed privacy legislation. It looks like a bill in Ohio is dead. Florida died. By and large, this is the issue that prevented a law from passing in Oklahoma. And I mention those three states because, interestingly enough, their legislatures are controlled by Republicans. And whereas perhaps Republicans have traditionally been viewed as the party who would not be in favor of private rights of action because they're viewed as those things are viewed as anti-business, you have seen significant segments of the conservative caucus in those states wanting there to be a private right of action, and disagreement over that has prevented them from passing. But there are other issues that continue to be sticking points. Like, for example, how is a bill going to define the data that is covered? And you continue to see in this country anyway, whereas I thought we were sort of past the debates since they were settled under GDPR and other laws, is a privacy law going to apply to modern online data sets? Will it apply not just to identified data, but to identifiable data? Data stored with persistent unique identifiers of all sorts of types, cookie IDs, etc. And we continue to see fights at the margins of privacy bills in this country on that sort of issue, which leads you to believe that business interests which do not do business outside of the US are still resistant and want to relitigate some of those issues. Mm-hmm. And so it's, you know, and we could talk about just that topic for a long time. You know, should a bill have pseudonymous data in it, or should it just be excluded, which is something we recommended. Don't put it in for a variety of reasons. How are you defining personal data? Is your definition of de-identified data sufficiently rigorous so that the bill will actually apply to modern online data sets?
Let me just add one point to what Ryan said, all of which I agree with pretty much. But you know, the GDPR is the model every place but here, right? I mean, just to be clear, you know, Japan and South Africa and Brazil, and, you know, all these countries that are adopting the GDPR model. You know, America's political culture is different than that, and it tends to be more resistant to kind of centralized regulation. And for a number of other factors, I think that there's a lot of reasons why we're going a separate way. I also want to say that might not be bad. I mean, one good story you could tell about the situation that we're in now, as we've all described it, is this might leave room for some experimentation, right? This might leave room for thinking about things in a new or different way, whether that be the board in California using its expert regulatory process to sort of add some cohesion and some rigor to things, or whether it be some of the bills we've seen out there that, you know, are a little bit more creative in the way that they think about privacy, are more moving towards sort of substantive duties of data custodians and work on the kind of theory of trust that Ryan talked about, and less these kind of individual rights kind of approaches that depend on consumers asserting their own interests as opposed to having a systemic approach. So we all learned in law school about our federalism and the ways in which it could actually have some benefits. That may turn out to be true here, especially if Congress continues to be completely stymied as they look like they're going to be for the near future.
Sorry, you'd think at this point I would know when I was muted, but Jennifer, there's a specific question that's directed at you, which I'll pose, but then I think there's also, it relates to kind of a broader question about institutional design and enforcement of privacy. The specific question is about the relationship between the CCPA and the AG's enforcement under California law, and whether it makes sense for the AG still to have enforcement authority, or what the relationship ought to be between them. But I think we could sort of generalize that by saying, in some ways, it seems like one maybe virtue that many of these state approaches have in common is that we do seem to be moving more toward comprehensive privacy regulation rather than sector specific kind of stuff, depending, again, on all the definitions and those kind of things. But then there's, as Bill's mentioning, lots of other ways that we could vary institutional design and sort of going it. So maybe experimentation is the answer, but I'm curious, Jennifer, particularly about your thoughts about that as you guys have been building, but then also, for the rest of you, kind of what are the various places about institutional design trade-offs that might be meaningful here?
Thank you. And I realize I skipped over the details of enforcement. So just to be clear about how the framework works, July 1st, 2023, the agency will gain administrative enforcement authority. The AG's authority will continue, its civil enforcement authority, its ability to take companies, violators to court. And there is a private right of action in the California law. It is limited to some data breaches, but there are 3 different paths to enforcement depending on what the violation is. So the answer to the question of whether the AG will continue to enforce, yes, they will still have some enforcement power, and the law contemplates that there will be collaboration between the agency and the AG in enforcement. In terms of institutional design, it does make sense, in my view, for the AG to continue to have civil enforcement power for at least a couple of reasons. One is that the AG has civil enforcement power of the whole gamut of California law, and being able to connect those things together makes some sense. Also, just so people understand, it's pretty unusual for an agency other than the Department of Justice to have authority to sue in California. So the Department of Justice usually stands in for agencies and sues. It's not unheard of, some agencies do, but this model is something that's pretty, is very common in California. So that also may be something that people may not be aware of.
If anybody else has, Bill, you have thoughts on that?
So, I mean, the other thing I want to say, so privacy is so unsettled that it often is a place where you can have kind of creativity by enforcement. And I mean, I would point to the Federal Trade Commission as an example of this too. Until California took these steps and then other states followed it, the closest thing we had to a broad privacy law wasn't a privacy law. It was Section 5 of the Federal Trade Commission Act, was a general consumer protection statute saying don't be unfair or deceptive. But sort of step by step with some really thoughtful, creative, good interpretation, and using enforcement actions as a way of building up an understanding. The FTC has really clearly defined a whole bunch of privacy violations as either unfair or deceptive, and therefore violations of consumer protection law. And we're seeing that same kind of thing happen in a bunch of states through attorney general actions as well. So one of the, you asked about institutional competence. I mean, one thing I think, and one reason I'm excited that California has gone in the direction of empowering an agency here is that, it would be a big mistake to try and capture everything in such a fast moving area in statutory language. You need a smart, good, creative enforcer to be helping the law evolve along with the technological and business practices. But we've seen it happening for some decades in privacy. And what might be the most significant federal thing that could happen would be if Congress gave some more money, as they've talked about doing, to the FTC, maybe some more authority in certain ways, and set them loose on some of the problems in ways that might be effective. And I think California is doing something in some ways parallel to that.
And from the business side, part of what businesses do is look at the specific priorities of the enforcer. So thinking through what is the Attorney General's most important priority in terms of enforcement, and then preparing your compliance plans and responding accordingly. So if we know that a priority of the AG is loyalty programs, for example, making sure that you're doing a deep dive into, if any actions of the business qualify as a loyalty program, if they're offering financial incentives, and making sure that that is going to meet the Attorney General standards. And then sort of just, practically, if a business doesn't have a budget for what would require full belt and suspenders compliance for every portion of the law, thinking through how to allocate resources based on those priorities.
We actually have another. Oh, I'm sorry. Go ahead, Ryan.
I might just add briefly, Mark, that I think, as Jennifer was mentioning, the sort of multi-pronged enforcement approach that California has, I think that's very interesting, and that you could have different enforcement mechanisms that may serve slightly different purposes. The Attorney General is a natural place in most states to put enforcement authority because they have traditionally enforced their Consumer Protection Act and may have experience dealing with privacy or security related issues. We thought this last year in Washington State, the inclusion of a data privacy commission was one of the more interesting aspects of legislation there. But we also think there is a continued need to have a discussion about providing consumers with the ability to seek redress and the ability to enforce their rights. And unfortunately, I think for much of the business community, the words private right of action send them screaming to the hills. And oftentimes, private rights of action are portrayed as a binary choice. It's black or white. You either have one or you don't. And of course, that's not reality. There are lots of different iterations of forms or mechanisms of seeking redress that consumers could conceivably be provided with that policymakers could consider. You could consider providing people with the ability to seek injunctive relief and attorney's fees to enforce their rights. You could perhaps provide them with the ability to seek actual damages and those sorts of things that may be caused by violations of their rights. And one of our frustrations across the country really has been that we have been unable to prod more stakeholders from across the political spectrum to have that more nuanced discussion about, what do we think a private right of action could and should look like in a privacy bill. And I think our inability to prod that discussion forward will continue to stymie more privacy bills from passing in other states.
Yeah, of course, California's got a sort of innovative version of that, right? Where there's a chance I have to actually present it to the AG before certain private rights of action get enforced. But Jennifer, and we're going to run out of time here, but Bill said something that you and I had talked about before that I thought maybe would be of interest to people when you're talking about the sort of explicit building into the California regime of the ability to update and to sort of pass new things. And I wonder if you could talk about that a little bit, because I think that is kind of a novel thing that gives it a real advantage to the agency.
Sure, thank you. There are a few places in the law where this concept is built in. The main one is what I mentioned when I was going through the list of responsibilities the agency has and the attendant authority. And one of them is specifically to keep up with telecommunications and other technologies and business models. And then in addition to the list of topics on which the agency is asked to regulate, there's a general bucket for regulations as needed. In addition, throughout the statute, there will be calls for further regulation or regulation to sort of add meat to the bones of things if needed. So for example, California's law as amended by CIPRA will prohibit the use of dark patterns. And dark patterns is defined, broadly speaking, as subverting the consumer's intent. It's broader than, say, fraud or unfair and deceptive. But then the end of the definition says, as further defined by regulation. So in that case, the agency could update that. And even in the specific list of regulation requests in the statute, it will say, if needed, update the definition of personal information. If needed, update this. So the message is very strong, and then the attendant authority carries along to the agency to pay attention to what is happening. I think this is really important, as I said, and one of the reasons, I'll use an example that Bill brought up, which is, what is the definition of personal information? For years, we had this concept of PII, personally identifiable information, that would be a name and an address, or maybe a combination. We talk about data breach laws, there's often, a few of these, and sometimes they're in combination. And some years ago, we developed the innovation of identifying, if it's identifying, it's going to be covered, which is more capacious and also future-proofed, because it allows for things to be drawn in as the technology and the data practices change. And that is something that actually I think is necessary in order for these laws to remain meaningful as everything changes around us.
Great, thanks. So we just have a couple minutes left, and I'm going to ask you guys the sort of maybe impossible question in this area, but that's a question about prediction of, like, where's this going to go, right? Billy, you were in the business of this by writing that paper, so I think it's a fair question. But a couple of years ago, I certainly wouldn't have predicted this flurry of state level activity. I'm not sure what I would have predicted at the federal level, probably nothing, but I'm not sure I would have predicted this. I guess I would have predicted probably more that everyone just would have kind of lived with GDPR. So I wonder if you have, if you could look into the future a little bit and the way things are coming, is the future, in the immediate future, is it just more state regulations? Is it a certain kind of model becomes the dominant one? People copy California more. Looks like there's another state that's now copying the Illinois biometric statute. I'll just leave it open-ended like that. If you could just each, maybe think about where you think it might go.
I think the actions at the state level, not the federal, for the foreseeable future, for a variety of reasons we've talked about. I think that we're seeing a continued refinement of how these laws work. Actually, CIPRA was in some ways a refinement of the CCPA, right? And I did mention in passing before, I think that there's some third way models out there that have some promise and that may start to get their way in a less theoretical, more real way into the conversation. Some bills in Massachusetts and New York are kind of representative of those. But the real center of gravity is, I think, going to stay in state capitals for some time now. And the question really will be, will that build up to a point where Congress finally feels compelled to act, or will it be like the data breach scenario I mentioned before, where it kind of passed the point of no return and then federal law never happened?
And if I can add on to that, Mark, I agree entirely that the action will remain in the states. And I don't think it's clear how things are going to turn out substantively. I think there are a lot of fights that are going to happen in state capitals. In my view, you will see some industry interests pushing legislation like the bill that passed in Utah, which frankly would not do much of anything. And I think you'll see efforts to push, whether it's California or the Washington state sort of model, push those, but try to expand them in some interesting ways. There are still questions around affirmative obligations you may impose on companies. So beyond sort of the obligations of data minimization, secondary use, purpose specification. But is there a role for fiduciary duties of some sort? Is there a role for a duty to avoid abusive trade practices? I'd suggest people look at Washington SB 5813, which was a bill introduced this year, which has some interesting ideas in that regard. And then the other piece on the data subject rights side of things is going to be, what is the role for consent? And what role does consent play? Will you require opt-in consent for just sensitive data, something we support? Or can you identify other activities that ought to be subject to consent? And how do you define those? And then how do you define the standard to meet to say you've gotten consent? Opt-in, opt-out, or is it somewhere in the middle, opt-out with, say, an easy button like a global privacy control?
I agree that I think we will continue to see sort of different iterations of state proposals, in particular because we now have state laws that do give consumers specific rights. And so I think we'll continue to see an expansion of that, as well as the ways in which companies use online and personal data continues to become under more scrutiny. And so part of it is those state-specific attorney general priorities as well, and the fact that they want to signal to the residents of their states that they are taking action in this way, they are protecting consumers, and they're doing something to respond to just the proliferation of companies using data and using data of consumers in a way that's not always apparent to us.
Jennifer, anything you want to add to the?
I won't make predictions, but I will say that my door's open if folks in other states are working on a law and want to talk about the California experience. And I'll go back some years ago to some research that I did and others did before me. Chris Hoofnagel and I together did some survey research in which we made value propositions real to consumers and asked them if they would accept them or not. Like, for example, is it okay for a company to take your contact list to offer you more friends? And this was in 2011, 2012, 2013 that we were doing these, and people just rejected them out of hand, and they had been for a while, since at least 2005. Some of this work had been ongoing. The message at the time was that people don't value privacy, they just let this happen. But people clearly valued their privacy. They clearly didn't like what was going on, and they didn't feel like they had any control over it. So the only thing that I would say about the proliferation of state approaches is that, in my view, my personal view, this is a bottom up push at some level. People are being responsive, or policymakers are being responsive to really what consumers and citizens want. And I think that the reason we have this proliferation is that basically the dam broke. And we're not going back to a world in which we can just say that consumers don't care about their privacy and they don't value it.
Great, that's a great place to end. Thank you all so much. This was a really great conversation. I'm going to invite my colleague, Michael Karanicolas, to come in just to plug a couple of forthcoming events here.
Hi, yeah, thanks so much to our moderator. Thanks to all of our speakers. I enjoyed that very much. That was a really interesting conversation. This is the second of 4 events in our Ziffren ITLP series on privacy and access. If you're interested, our next event is on March 28th on data protection and entertainment. There's a link to register for that in the chat. And then the final one is April 20th on privacy, access, on privacy, anonymity, and public access, which I don't think we have a registration link for that, but stay tuned and it'll be up shortly. And for folks within the UCLA community who are tuning in, you can also join us on March 29th for an in-person event on careers in the tech sector, where we'll have fantastic lawyers and representatives from different folks in the tech ecosystem, including Natasha, who can talk about what it's like to work in tech. So thanks again to our panelists for a fantastic conversation, and everybody enjoy the rest of your day.
Yeah, thanks very much, everybody.